But on this side, we have to complete the arguments today. We complete the wrap up the arguments of this side today. No question of going beyond today. We have now heard two learned senior counsel who have taken us through everything. Maybe a third learned counsel on this side would also be arguing. Everybody else may now,
My lord, I just asked
lunch,
20 minutes.
at lunch, no, at lunch,
End of the day,
all,
10 minutes.
at lunch, 1 second, at lunch, all of you please sit down and ration the time in such a way that by 4 o'clock, this side is complete. So that, no further, and then we have to give the other side enough time. So
May I submit one aspect, my lord?
now 1 second. If I'm having a very long telephonic conversation, my better half only does this to me, which is please now get on with your work and stop the conversation. So I'll just say on the mentioning, no more mentioning. Dr. Singh, we please argue.
I'm obliged.
Only one aspect, my lord, regarding an intervention petition, my lord. May I submit, my lord, with your lordship's indulgence, one aspect regarding the intervention application, my lord. I've moved an intervention application. I'm only seeking, my lord, less than...
Ma'am, there'll be 150 interveners. Please don't mention because we have to hear everyone else on the intervention now.
Because, my lord, certain theoretical aspects, my lord, of...
anomalies, if we are not on other acts, heard in just a little bit of fullness. My lords, if one extra day perhaps could be given.
No. Therefore, absolutely.
The heterogeneity, my lords.
There are Supreme Courts where the entire argument would have been over in 30 minutes. We have given now 3 days in this court. I think that's good enough. Yeah. We have.
No, we had indicated from the beginning that we are focusing on one issue, and therefore we are going to deal with it. Therefore, the requirement of other interventions, other periods, the nuances is not something we are looking into. So, just expanding the field again is contrary to what we had constricted to.
One of the issues which are not dealt by my learned students. One of the issues are not dealt.
1 second.
If there are 9 people and 9 people want to argue for 2 hours, what's the point of taking up a matter?
No, it is on. We are only seeking, my lord, a short time of...
Say, from 2 o'clock to 4 o'clock, you lordship may indicate the time. And everybody follows the time.
Yes.
We don't mind. Please don't be like...
Just 1 second. Just 1 second. Just let's switch off. Dr. Singhvi, we will request Dr. Singhvi to conclude his arguments in 45 minutes by 12:15. And between Mr. Ramchandran and Mr. Vishwanathan, we'll give you an hour and 15 minutes.
First petition in the category.
So therefore, we are giving between the two of you, Mr. Ramchandran and you, 1 hour, 15 minutes.
I am separate category. But why should one person get more time than the other? Because there's a diversity of views. That's why Milord Lordship remembers.
You know, Mr. Grover, at the end of it, you have to otherwise.
No, I appreciate.
What we were thinking was next week,
Yes, my lords.
we will sit on Monday, Tuesday, Wednesday, and Thursday.
Yes.
Right? Next week we will sit on Monday, Tuesday, Wednesday, and Thursday. So we'll take it as we did in the case of Ayodhya. We had no miscellaneous. We were working through the week.
We are prepared to.
So we must. Really go on in July. We have no problem because all.
We'd be very grateful.
I'll tell you why. Because after next week, this bench, Justice Call is traveling. My lord is not available after next week for a week. I mean, we have no problem. We'll keep it in July.
Your Lordship,
My lords, Monday, just Monday, my lords, pro rata, our time can be divided, the times that we have specified, the times that, subject to Mr. Ramachandran and Mr. Vishwanathan's agreement to this 1.5 hours, the rest of us will divide it pro rata and we will finish on Monday, my lords.
Absolutely no problem, ma'am.
Because
We'll go until August.
so they-
No problem. We'll go until August.
yes, because the
No problem.
Lordships
Just
will,
Bhatt is retiring in October. We'll take up new bench after October.
no, your Lordships will appreciate, my lord,
Go on,
that
Merity.
the councils who have started the arguments, my lord, of course, have an advantage because they've.
No problem. We have no problem. Let everybody go on merrily. There's no problem. We'll hear this. We'll also hear this.
You may not be saying this.
No, my lord, we are only seeking.
Either very clear, and I'm putting it very clearly. Chief has put it very politely. I'm putting it to you. People have to be bound by time.
Yes, my lords.
One.
My lords,
But
that
two,
is our commitment from
if
the bar.
on a particular side of different nuances and 10 people, it can't be that 10 people will argue ad nauseam. Then you point
Absolutely.
out only that nuance of it.
Yes.
And makes
Absolutely, my lords.
We are giving everybody, but when you say everybody wants to look at the time schedule given, is this a realistic time schedule?
It was prepared in a different context, my lords. We'll cut it down pro rata.
People also know this case has been taken up with some priority. We are trying to see to wind it up. You don't want to wind it up, then don't wind it up.
My lords,
Go on.
my lords, we'll just take, yes, just 20 minutes.
Nobody is averse to giving 20 minutes. But when you say somebody needs 1 hour 45 minutes, somebody needs 1 hour 30 minutes.
See, this estimate which you have given us is 16 hours.
Correct.
16 hours of hearing. Now, 16 hours of hearing effectively means, therefore, that if we
One
start
week.
at 11:15, that means that we in a day we get 2 hours 45, 2 hours about 3 hours 45 minutes. That is 4 complete days on one side. How can we do this? We've already
Time is cut down, my lords.
possible.
If the time is cut down, then
Stick it
this
to
time
20
can be
minutes.
substantially
My lord,
decreased.
stick to
We
20.
appreciate what's falling.
Just see, Vrinda, your time period, which has been given, and this is 1 hour 15 minutes. We are not denying you that. We will not deny you that. Not deny you that. Certainly, we will not deny you that. But everybody must wind up in that 15-20 minutes, which you
Yes.
get. That's what we are saying.
My lords.
When it's being rationed out, it should be equitable ration out.
Of course, we'll do that.
Then why should one person get 3 hours and another 10 minutes?
People who have no.
But Mr. Grover, the person who opens, as you start in, Mr. Grover, we know in every matter. Why this matter? Even in a regular civil appeal or criminal appeal, if there are 10 accused, then after the first person has argued, the others basically
appreciate
want to
this.
supplement some
20
different,
minutes.
some nuance, what is all.
My lords.
It can't be like this.
It can't
It
be.
can't be like this. After
My
the
lords.
first two finished, I think we've been taken through most of the things between Dr. Singhi and Mr. Mukul Roy. Now you are saying there are certain nuances which everybody wants to address. That nuances cannot be addressed as if you are beginning a new case and addressing.
No, my lord. No, my lord.
Of course.
Absolutely not, my lords. My lords,
We-
this
we'll
court
take
is
it-
way
we'll
ahead of
give-
the US Supreme
as
Court.
and
We
when
will adopt that, the US
As we
Supreme Court.
see the development, as we see how much time is being taken, we will ration times accordingly.
And we'd like other counsel at the upfront, when they before they open, to tell us what they are going to argue.
Yes,
And
yes,
confine it down to the time which we will ration.
absolutely.
Be
We'll do
limited.
that. We'll all
My,
do that.
my lords, there is an intervention
You know, the other thing,
application.
I'm telling you another thing, and that Mr. Solicitor, Mr. Dwivedi, forget this issue, and your arguments. If constitution benches really have to go on, which 5 judges leaving their regular work, that's why chief justices before me have not constituted constitution benches, because you don't know the kind of pressure. Every evening I ask, what is the filing? How much is the disposal? We don't want to add to that's the real problem in our court.
Yes.
The inflow is so heavy. Unless we start rationing time, it's impossible to list constitution benches.
Then your lordship may say that after Dr. Singh leaves, everybody's rationed out. We don't mind. that.
My lords,
15, whatever your lordship wants. In the interest
See,
of time.
may I just say one?
Yes.
All this oral hearing which is happening is meant to give some voice to the people.
Correct.
But our real work begins after that, right? So don't be under the impression that if you don't get to address to your heart's content, we will not apply our mind. Our duty lies elsewhere. That once this is over, the whole court system is right now geared as though everything depends on what you say or what you don't say, which is not correct. Therefore, please keep that in mind. Restrain yourself to the extent possible and present the clearest picture without taking us through too many things. If you start referring, then we will be shuffling pages. Our focus will be there. You want to argue, you look at us, make your point. Somebody said US Supreme Court. Do that. Then don't refer to anything, just refer to the pages.
we will do that, my lords, and subject to my lord's preference, perhaps we could take that note, cut it down pro rata, and we will finish by Monday for sure.
All right, now what we'll do is, we have now indicated, we will start hearing Dr. Singhvi. Dr. Singhvi, wrap up by 12.
Lord, your lordships are, Lord, really
please.
keeping it on Monday.
45 minutes starts at 11:40 minutes, provided it starts.
Lord, your
Provided
Lordship,
12:30 that. Now,
He said
11.
yesterday,
I'll be racing.
yeah, we gave you a compliment of the expertise too.
No, Malas, your lordship will see. I am not going to repeat a thing. I am only saying, please count my 45 minutes from when I start.
One-
That's all.
all right, Dr. Singhvi, we start now. Your time
Only one-
begins now.
yes.
Only
Yes.
one clarity,
So
Lord.
turn to Malas, turn to 140.
So what is your lordship's direction?
After this, yesterday we indicated we are going to hear Mr. Vishwanathan. Mr. Grover, you can argue after Mr. Vishwanathan. Mr. Raju Ramchandran after that for a bit. Then we'll hear. You've given us the order. That's great.
Yes.
No.
Your Lordship,
Can I?
one.
All right. So after this, Mr. Ramchandran, then Mr. Vishwanathan, Geeta Luthra, Mr. Grover, Jaina Kothari, the order which you have given us in the.
There was an initial list, my lord, which was circulated by the nodal council, in which my name was included, and that seems to be, my lord, omitted from the revised list. I've communicated with the nodal council. I'm only seeking, my lord, a 10-minute
Who are you
time,
appearing for?
not more than that.
Why are you
In
appearing?
support of the petitioners, my lord.
In
support of the petitioners in the,
What is
the
it?
main guy.
Whom?
For a gay activist, my lord, from Bombay.
50 gay activists, are we supposed to listen to every gay
No, my lord, I'm only seeking a very short time, merely because
No,
my lord,
but tell us.
the theoretical aspects, my lord, of anti-discrimination law,
The issue
in
is-
particular, my lord, the theory of disgust by Mata Nuzma, only to elaborate on that, I'm only seeking 10.
Anybody who's an activist should come and address this court.
No, my lord, only
Now, proceed.
That
because, my lord,
can't work out like that.
Not like this.
How much time is your lordship saying?
Ma-
Anyway, Dr. Singhvi will complete at 12:30, and Mr. Ramchandran thereafter by 1 o'clock. When we rise for lunch, we would have.
Basically. As I
Now,
understand.
can we
No, you can't tell over.
start now?
Grover, 1 second.
We will take it and.
Let's start now. By 1 o'clock,
Okay.
we would have completed with Dr. Singhvi and Mr. Ramchandran's argument.
Now, your lordship's
I would
PDF.
request, my lord, only 10 minutes of time, my lord, because this court, my lord, is not
tell us
usually it does not
I'll
restrict
tell you one
arguments
thing.
of councils.
Look,
That
we are
is
also
why.
not ignorant. I've read Mata Nazbom extensively, and I still continue to read Mata. That's why after my day's deed is done in the court, this is what we sit down and read to get some sanity in our mind also at the end of the day.
I'm
For
only,
Mata Nazbom, do you have to keep on interrupting by the minute over here? I'm appearing for a gay activist. I want to show you Mata Nazbom. Of course, just give us a note. We'll read it.
Malas,
My lords,
indicate
my
That's a
lords,
matter
I'm
of
also
joy for
caring
us
for
to
one
read.
of
It's
the
a matter of joy
intervenants.
for us. Justice Bhatt
PDF
said,
1180 minutes.
I mean,
My
it's
lords,
difficult to tell you. I was factoring that, okay, now summer vacation is going to be on this judgment. We'll have enough time. There's not, the pressure of SLPs is not there. We'll sit down. So give us a note on Martha now.
The written submissions are already there. Only to indicate, only to take your lordship through that. Only I'm seeking some time. That is after
my
the petitions
lords,
conclude, my lord. There won't be any repetition on from my side.
Somebody will
My
then say, I
lords-
want to now point out Rosalind Dixon. Why just
my
Martha?
lords, I
Somebody
will
say,
seek
I want to
indulgence of
point
my
out
lords
Bruce
only for 2
Ackerman.
minutes, my lords.
All right,
PDF
we'll love to
11.
hear it. I mean, I have this all of it threatening to fall on my head in the night. I've got such a pile of unread books.
PDF page 1180. Let me that's
Yeah.
the one.
Chalo,
Would your lordships continue
PDF
on
page
Monday
1180.
also?
Yeah, we'll start on Monday.
My lord's prerogative, my lord, Monday is a working day, my lord. My lord,
There's also working. No?
no, my lord, it's admission day, my lord. There are several matters, my lord, which are already.
All right, we'll see, solicitor.
But let this start, my lord. On our side, your lordships may give us.
Solicitor, have you ever seen us being unreasonable in the court? Then, just we have to put a little pressure on everybody so that is right. Yeah.
Your lordship would not curtail us, but I'm confident about it.
Your lordship has binary request. One request,
Otherwise, we are
one
answerable
request.
to our
not
own
to us.
conscience, solicitor. We are
Your lordships
never will
would
until
be
we
guided
feel that
by
we have heard the matter fully. We'll,
Now, Malas, 1180 PDF.
All
I'll just race through, Malas.
just 1 second.
What do you want us to open, Doctor?
1180, Malas, PDF, that compilation of last evening.
143 that we will.
I'm grateful. 142 is over, 143 and 144 gets Malas,
Volume.
Baroness Hale over.
Volume 2.
Not precedent. Volume 4 foreign. मेरा तो volume 4 है.
Yesterday evening, Baroness Hale, PDF 1180, para 143. Volume compilation 4.
Volume 4 foreign judgments.
Yes, it's actually open.
It follows.
Just a moment, please.
143 you were reading. Huh?
Correct.
That's where we stopped yesterday.
Correct, please. May I read?
Yes, please.
Yes.
It follows that a homosexual couple whose relationship is marriage-like in the same way that an unmarried heterosexual couple is marriage-like are indeed an analogous situation. Any difference in treatment is based upon their sexual orientation. It requires an objective justification if it is to comply with Article 14. Whatever the scope for a discretionary area of judgment in these cases may be, this is very beautiful, but it can be transplanted subject to my Lord discretion to this Indian Supreme Court, to our Article 14. Whatever the scope for a discretionary area of judgment in these cases may be, there has to be a legitimate aim before a difference in treatment can be justified. But what could be the legitimate aim of singling out heterosexual couples for more favorable treatment than homosexual couples? It cannot be the protection of the traditional family. The traditional family is not protected by granting people, which is denied to people who cannot or will not become a traditional family. What is really meant by the protection of the traditional family is the encouragement of people to form traditional families and the discouragement of people from forming others. There are many reasons why it might be legitimate to encourage people to marry and to discourage them from living together without marrying. These reasons might have justified the act in stopping short at marriage. Once it went beyond marriage to unmarried relationships, the aim would have been to encouraging one sort of unmarried relationship and discouraging another. The Act does distinguish between unmarried but marriage-like relationships and more transient liaisons. It is easy to see how that might pursue a legitimate aim, and easier still to see how it might justify singling out the survivor for preferential succession rights. But as Lord Justice Buxton said, it is difficult to see how heterosexuals will be encouraged to form and maintain such marriage-like relationships by the knowledge that the equivalent benefit is being denied to homosexuals. The distinction between heterosexual and homosexual couples might be aimed at discouraging homosexual relationships generally, but that cannot now be regarded as a legitimate aim. It is inconsistent with the right to respect for private life according to everyone, including homosexuals, by Article 8 since Dudgeon's case in 1981. If it is not legitimate to discourage homosexual relationships, it cannot be legitimate to discourage stable, committed, marriage-like homosexual relationships of the sort which qualify the survivor to succeed to the home. Society wants its intimate relationships, particularly but not only if there are children involved, to be stable, responsible, and secure. It is the transient, irresponsible, and insecure relationships which cause us so much concern. Last para to be read. I have used the term marriage-like to describe the sort of relationship which meets the statutory test of living together as husband and wife. As husband and wife. Once upon a time, it might have been difficult to apply those words to a same-sex relationship because both in law and in reality, the roles of the husband and wife were so different and those differences were defined by their genders. That is no longer the case. The law now differentiates between husband and wife in only a very few and unimportant respects. Husband and wives decide for themselves who will go out to work and who will do the homework and childcare. Mostly each does some of each. The roles are interchangeable. There is thus no difficulty in applying the term marriage-like to same-sex relationships. With the greatest respect,
Dr. Singhvi, this was a case where the Act squarely applied to unmarried relationships.
Yes.
And the principle was that if you're unmarried, if the Act applies to unmarried relationships between heterosexuals,
yes,
there is no basis to exclude unmarried relationships among homosexuals.
It is the second last formulation of the Lordship sentence which I am concerned about, that when you have a particular paradigm applying to a heterosexual group, your Lordship, absent something very special, will find it discriminatory not to apply it to
another. BaiManus Hale uses the expression marriage-like relationships.
Yes.
So these are not marital relationships, marriage-like relationships of heterosexual couples who are in a stable relationship, but who are not married. They said that therefore, if you are extending protection to heterosexual couples who are in a marriage-like relationship and therefore not married, there's no basis to deny it to homosexual couples who have a marriage-like relationship but who are not married.
I'm grateful, that's one. But the language of the paras I've read yesterday and today
maybe also very, very of extension. You're right.
And your Lordship is not bound by these judgments. Your Lordship will find persuasive value to the extent your Lordship finds. Now I turn to that article, which according to me is one of the most well-written articles on interpretation. On reading down, reading up, what your Lordship
which is that article now?
Treaty compliant, or in our case, constitution compliant reading. Constitution compliant reading. Kindly hand over. It's better to use the hard copy. I'll read only 3 sections, a few pages of it. Kindly hand over.
Oh, okay. Sorry, I was just. Thanks.
We also emailed you, but this is better and quicker. The Lordship may mark this.
The judgment is done?
That is done. That is over. Now, kindly come to the first page. What is the year of this? What is the year of this publication? Don't do multiple things. Focus. Year. Just come to the first para. You will ignore. It's about UK and New Zealand. Second para on the first page. On the first, I'll be making you mark only some portions. It's rather well put, and it is triggered by. That's the reason I'm citing it. The key question for the courts in applying such directions is how to determine when it is or it is not possible to ascribe a rights-consistent meaning to the legislation. Although a definitive answer to that question has proved unsurprisingly elusive, a shared assumption to date has been that the line that is being drawn, this is the point for us, line that is being drawn between interpretation on the one hand and legislation on the other. The task assumed by the courts is to search for an interpretation of the relevant statutory provision that would bring it into conformity with human rights standards. Now come to page 2, Beyond the margins of interpretation, however, lies the constitutionally impermissible territory of judicial legislation. And that's your Lordship's equation. The next parameter, given this characterization as essentially interpretive, it is perhaps unsurprising that I'll skip the New Zealand specific para, come to the third para. In the United Kingdom, however, and this is important, a new model now seems to be emerging. In a series of cases, culminating in the decision of the House of Lords in Ghedan, I just read it, the United Kingdom courts have cast doubt over the centrality of statutory language to the determination of whether a rights-compatible reading of legislation is possible in the right of the Human Rights Treaty. The text is not the law lords have said, determinative. The text is not determinative. Rather, the courts will be constrained only, mark the word only by the underlying thrust of the legislation A and the limits of their institutional capacity. Now, Malas, the counter question, the devil's question, is posed in the next paragraph. This paper discusses Ghedan and its implication. It suggests that the remarkable aspect of Ghedan is that it simultaneously divorces the process of statutory interpretation under HRA from the twin anchors of parliamentary intention and statutory text. This I'm relying upon heavily, Malas, this first sentence. The second part, in that light, it is suggested that the dichotomy between interpretation and judicial legislation is at the very least under pressure, and the courts are in fact appropriating to themselves a significant, if nevertheless a subsidiary slice of legislative power. Now come to Malas, page 8. This is page 8. So, where did you write it down? Page 8. Of the four law lords in the majority,
Yes.
of the four, page 8, Malas, 8. Roman, big Roman 2. Of the four law lords in the majority, the names are given. All but the last delivered a separate opinion on the correct methodology under 3.1. There was, however, substantial agreement on these essential principles. Then the key issue, separating the sheep from the goats. Their lordships identified the key issue under 3.1 as being how to determine the limits of what is possible. The scheme of 3 and 4 of the treaty envisages that there is a Rubicon which the courts may not cross. What is not, however, spelled out is the test to be applied in separating the sheep from the goats. Parliamentary intention is not the touchstone. This is another red herring which your Lordship may have to deal with in the present case. In investigating the line between the possible and the impossible, Lord Nicholas and Lord Stein held that the courts were not constrained by the intention of the Parliament that enacted the legislation. Very, very important. Lord Nichols distinguished the required approach in this respect with the orthodox approach to standard statutory interpretation, which involves seeking the intention reasonably to be attributed to Parliament in using the language in question. In contrast, Section 3 may require a departure from that parliamentary intention. Departure from that parliamentary intention. The key question being how far and in what circumstances. This is because there is another and a countervailing parliamentary intention which needs to be given full weight. Namely, Malas, the intention reasonably to be attributed to Parliament in enacting 3. So it's an objective test being brought in. Objective. Now, nor is the statute. The second thing which is not determinative is statutory text. And Malas, it is quite interesting and astonishing, though now in a constitutional context, American English courts are saying this. When we were brought up, Malas, it would be sacrilege to suggest this to an English court. Remarkably, their lordships held that the language of the statutory provision at issue is not the touchstone in deciding which it is not possible under 3.1. This holding had a number of dimensions. Further, their lordships expressed concern about excessive concentration in a literal or technical way on the linguistic features of the statute. Rather, Section 3 requires a broad approach, concentrating amongst other things in a purposive way on the importance of the fundamental right involved. So intention one way, statutory text one way. Now we've got a third test, importance of fundamental right involved. Secondly, their lordships stressed that the proposition that ambiguity in the statutory language is not a prerequisite to the operation of 3.1. Ambiguity is not your lordship's poll star. Thirdly, 3.1 might thus have a role even if the statutory language is not capable of bearing two meanings. Lord Nichols says, once it is accepted that 3 may require legislation to bear a meaning which departs from the unambiguous meaning the legislation would otherwise bear, it becomes impossible to suppose that Parliament intended that the operation of 3 should depend critically upon the particular form of words adopted by the parliamentary draftsman in the statutory provision under consideration. That would make the application of 3 something of a semantic lottery. From this, the conclusion which seems inescapable is that the mere fact that the language under consideration is inconsistent with a convention-compliant meaning does not of itself make a convention-compliant interpretation under 3 possible. So this is impossible, I'm sorry, impossible. So your Lordship's ultimate guide star is intention, no. Text, no. Parliamentary, well, is overall purposive theological, no. But the ability to achieve a convention compliant result. A convention compliant result. Next page, Willis, at page 10, I'll just read the quotation. Fourthly, their lordships considered that 3.1 empowers the court, if necessary, to change the meaning of the legislation. This is actually the heart, the legal heart of this case is this, Willis, interpretation, how to look at these sections. 3 enables language to be interpreted restrictively or expansively, but a 3 goes further than this. It is also apt to require a court to read in words which change the meaning of the enacted legislation so as to make it convention compliant. It is apt to require the courts to read in words which change the meaning of this enacted legislation so as to make it convention compliant. In other words, the intention of Parliament in enacting 3 was that to an extent bounded only by what is possible, a court can modify the meaning and hence the effect of both primary and secondary legislation. Their lordship's view is not the touchstone in determining whether a convention compliant reading of legislation is possible, begs the question. If not the words, then what? How then is one to sort the sheep from the goats? Their lordships identified 2 overlapping limits. So now he's answering the question, how do you separate the sheep and the goats? What is possible under 3.1? This is the first test, fellows. General thrust of the legislation. Second is court's institutional capacity, which is defined later on, coming out later. As to the first, their lordships held, 3.1 does not authorize the courts to adopt a meaning that is inconsistent with what they variously described as fundamental feature of legislation, underlying thrust of legislation, grain of legislation. Each of the footnotes gives the lordship the para. A cardinal principle of legislation, the very core and essence, the pith and substance of the measure. Well, is to take a 5-second aside. It is a kind of a basic features intra-legislation. Basic structure doctrine, intra-legislation. Right. These are well interesting developments. The lordship is...
The tenor and the provision
Tenor.
of the law.
Exactly.
That internal, does it make
internal sense? It has to be intra.
You can't confine it to...
Correct.
Wow.
This notion that the courts cannot turn, page 11, 11, top. This notion that the courts cannot turn the scheme of the legislation inside out overlaps with the second point, which is that the courts cannot make decisions for which they are not institutionally equipped. Now, what is the meaning of this? Some cases that lordships held call out for legislative deliberation. So, if it's a case where a lordship finds the whole script has to be written, it has to go to the legislature. This might be the case, for example, if the exercise of making the legislation convention compliant would involve the substitution of a detailed statutory scheme. It's a very fair test, fellows, very fair test. Or if a policy choice needs to be made between different methods for achieving convention compliance, or if the decision would have far-reaching practical repercussions, the courts are not well equipped to evaluate. This has to go case by case, fellows, to your lordship's ultimate decision. Now come to 13, page 13, 1.3. In Ghaidan, however, lower part, second half of the page. In Ghaidan, however, the House of Lords rejects both a focus on text and a focus on purpose. I'm sorry, Justice Kohli doesn't have page 13, lower part. I'm just doing a little bit of speed reading, Your Lordship's permission. Now, Your Lordship, teleological purpose, Bennion. So even that is out. Both a focus on text and a focus on purpose. This creates something of a puzzle as to what their lordships might mean when they say that the interpretive possibilities created by 3 are limited by the underlying thrust, 1, of the legislation. Considered in isolation, that proposition might sound a restatement of the modern purposive approach to statutory interpretation. The purposive approach has, however, been explicitly rejected by their lordships. The intention of Parliament in enacting the relevant legislation must, they said, give way to the intention of Parliament in enacting. That the underlying thrust approach is not consonant with the purposive approach is manifestly evident from their lordships' analysis of the statutory scheme, page 14, top, at issue in Ghaidan itself. Lord Nichols postulated that the social policy underlying the extension of security of tenure in 1988 to survivors of de facto opposite sex relationships was equally applicable to survivors of de facto same sex relationships. On the basis of that essentially normative conclusion, he held that the underlying thrust, this is the test for us, the underlying thrust of the Rent Act of 77 did not preclude a convention compliant interpretation.
So then
The underlying
two parts. One is yes, this is how you make it consistent with the convention. The second is they abandon the purposive construction method.
and the textual and the intention based. Now, if your lordships were to find
Was it? Diametrically.
well, if there's a prohibition, I would say, in fairness, the answer would be no.
Then
If the language is diametrically opposite.
interpret it to
No,
choices
the
of the
lordship
court.
is, when your lordship puts that question, I am answering it saying that diametrically opposite must mean prohibition.
The prohibition, there could be.
Prohibition.
We are looking.
Answer has to be no.
let us- let
I'm
us-
not here, Manus, to suggest your lordship that your lordship has a prohibition and your lordship is then overriding it on this basis of interpretation. Then your lordship may be able to override it for Manus some second argument. It's not the only answer. Second answer is
But if
your
not
lordship
provision,
as not constitutionally compliant.
then
Manus,
when-
there are two ways of looking at this. One is that we challenge it on the ground of unconstitutionality, as we are doing the notice and objection provision to which I have just returned. Your lordship will then apply that test. The first test, my lord Justice Narasimha is asking me, is intra-legislation. To that, the answer would be there's a prohibition, and I still ask you to only interpret. Your lordship may have
How can
difficulty.
we confine to that concept that if there is a prohibition, then only we say that it should go back to the legislative drawing board? Because
No, if it's not constitutionally compliant on the larger challenge, no, your lordship can strike it down.
let me complete. We are focusing our gaze on the only provision. In Gaidan, it was possible. Gaidan, the question was simple. And also, Gaidan was not essentially concerned with matrimony. Essentially, it was concerned with protecting tenants and whatever was the consequence if one of them who was living in a relationship died. So therefore, it was possible to not even go into the internal mechanics of the concerned enactment. Here, perforce, whether you like it or not, we will have to insert ourselves into the mechanics of.
Therefore, Manus, therefore, two things. Ghedan, the underlying, although the issue was Rent Act, the underlying thrust was found by all 5 judges to mean that you cannot discriminate between heterosexual couples versus homosexual couples in the interpretation of that act. Number 2, the question would be if your lordship found that SMA, the underlying thrust, is not this, or the SMA precludes that underlying thrust, then your lordship would go one way. If your lordship, however, were to find that the underlying thrust of SMA does not exclude, and that's the heart of the answer to my lord's query, does not preclude or exclude a same-sex couple, that's follows. Therefore, that choice ultimately follows the.
If presented the way Gaidan is presented, we have no difficulty. But if you take the steps in Gaidan, which is the internal sense of the enactment, then we will necessarily have to go into
the two different acts. Lordship, naturally, this is Gaidan is something else. This is something else.
Then
I'm only on the approach.
The route which we may have to take is something else.
Well, I'm only giving your lordships a approach to interpretation,
yes, you're right.
which should comment your lordship, obviously in a different context.
It's a very novel approach.
Novel approach and a
But
different
having
context.
said that, here you're really leading us on the path of statutory interpretation.
That's true.
Statutory interpretation, not based on text, not based on intention,
Go beyond.
not based on original intention, not based on purposive teleological
So
interpretation.
you're really asking us to read into the statute the expression spouses for really man and woman.
So does the underlying thrust of SMA exclude your lordship's reading or insertion or understanding of that construct? Is the
Because your principal premise is that when the legislation was enacted in 1954,
yes,
the object of the legislation was to provide a form of matrimony for people who are not falling back on their personal law of marriage.
Absolutely.
Right? And not
Special categories.
You are giving Parliament was intending to provide an avenue to people beyond your religious, the religious governance of marriage, so to speak.
Yeah. There was also an aspect of endogamy.
Yeah.
There was an aspect of endogamy which we cannot ignore.
Yes.
So it was an all enfolding kind of a legislation.
And it cut across so many spectrum because it was intended to
And
be a very
therefore,
special category.
after 1954, in the last 46 and 69 years, our law has really evolved to recognize the fact when you decriminalize homosexuality, you also realize, well, these are not just one-off relationships. This also comprehends a stable relationship.
Because you go back and
Therefore,
say,
by decriminalizing homosexuality, we have not just recognized fleeting relationships between consenting adults of the same gender, right? We have also recognized implicitly, therefore, the fact that people who are of the same sex would be in stable relationships. Now, if the object of the law in 1954 was to bring in its fold people who would be governed by a matrimonial relationship apart from their personal law, then surely that law is capable of being broadly read according to you, so as to take into account more stable relationships.
let me put it bluntly,
the same
very
sex
grateful.
as well.
Let me put it bluntly. When you enacted the law, you did not, in the debate in Parliament, in the writing of the draftsman, when I get up and speak on it, may not have got homosexuals in mind. You may not have considered them.
That makes no difference.
Another way which you are perhaps propounding is this provided a framework, but that framework is of the concept of marriage. The concept of marriage transcends contemporary understanding to
it's an evolving dynamic concept.
to comprehend an evolving idea
Dynamic,
of
very dynamic concept.
So used in a constitutional sense, it only provides a framework.
Framework.
And that framework is broad enough to, assimilate later developments.
I
So
don't
it
want to
transcends the existing.
I don't want to sound well as that is really well put with respect. The provision of a framework which departed from the existing framework already, because it took care of personal laws. Now, in that framework, are you cast in stone, or are you in an evolving dynamic picture? And can the underlying thrust and your lordship's institutional capacity sustain it? This is the summary of the whole Ghaidan principle applied to SMA.
And from the perspective of institutional capacity, we have to ask ourselves whether we would be doing something which would be fundamentally contrary to the scheme of the statute.
You also have to make a new statutory scheme.
Yeah, exactly. Would the
New
court be
statutory
rewriting the entirety of the statute? Would the court really be making policy choices which is for the legislature to make?
Lordship.
So long as we don't straddle that line which divides policy from the judicial process, you're still within the fold of it.
I'm very grateful, which is why they have put this second test. The
But
first test was
I
enough.
think the impact of
Put a
Ghaidan
line.
is to liberate the court from the very, very traditional approach of looking at everything as a matter of statutory interpretation. Therefore, purposive interpretation also falls back on interpretation of that statute and the language of that statute.
That is important, Malas. That teleologic and purposive also, which is supposed to be an advance, falls back.
I'll play a little bit of a spoiler. Ghaidan provided the framework for the introduction of a law in 2004, which assimilated all these developments, which led to the blessing of statutory recognition of these kind of partnerships. And then it took another 10 years for these to be recognized as marriages. So that too is an aspect which we will have to keep somewhere in mind.
Absolutely, Malas. Your Lordship, that's the difference. It's a holistic thing your Lordship keeps in mind. Ultimately, the feel of the case is only a Lordship will. That is, nobody can be identical. Nobody is saying it.
I'm sure if you go to Ghaidan and if you follow it up, there could be other cases which have followed
now,
that.
So I've now given my time. I've done this.
Dr. Singhvi, I think, looking at India constitutionally and socially as well, we have already reached the intermediate stage, right? The intermediate stage postulates that by decriminalizing homosexuality, your very act of decriminalizing homosexuality does contemplate that therefore people who belong to the same sex would be in stable marriage-like relationships.
Marriage-like is the operative word.
Right, marriage-like relationships.
Live together.
Because the moment we have said that it's no longer an offense under Section 377, therefore we necessarily contemplate that you could have a stable marriage-like relationship between two persons who do not treat these as chance encounters, but as something more than that, not just a physical relationship, but something more of a stable emotional relationship, right?
Societal.
Which now is an incident of our constitutional interpretation. Once we have made that, we have crossed that bridge, then the next question is as to whether our statute can therefore recognize not just marriage-like relationships, But relationships in the relationships
On the
of
contrary,
marriage.
Mills, I started by saying it's a logical move in the same direction. It is, in fact, little done, vast undone. Your Lordship is now getting to cover that territory because to merely decriminalize is one category. Otherwise, it does, in an actual daily sense,
Of
remain
course,
a
it
shell.
requires us to, of
Hollow
course, it
shell.
requires us to redefine perhaps the evolving notion of marriage, because is the existence of two spouses who belong to a binary gender necessary, or the requirement for a relationship of marriage? Or has our law now progressed sufficiently to contemplate that the existence of binary genders may be, but is not necessary for your definition of marriage?
And Malas, to that comes in the intersection of the Article 14. You in your counter and everywhere else are underlining immeasurably the vital importance of marriage, to which I bow down. But that vital importance of marriage is restricted to one category.
Expanding that definition, are we then trenching upon that area which Gaidan excludes to the judges?
That is, Bilals, in case your Lordship has got to stitch a whole cloth, which only a statute can do. That ultimately will be your Lordship's call. I don't think at all, which now, Lordship will just note on the side, para 44 has some other cases similar to Gaidan. I'll not read them. I don't have time to read them. Para 44 of my submissions. I'll now come to Bilals that 3 or 4 queries arising under the SMA, and then come to the notice of objections regime.
But in a way, Dr. Singhvi, I think what happened in the UK is really, in that sense, not in that. I was just talking to Justice Call, is not really in that sense in all fours with what happened in India.
Not at all.
The HRA in the UK was intended to enforce treaty obligations under the ECHR.
Yes.
Right? For us, we've always had the overarching principles of the Constitution, which lie above.
That's the irony. We are A for sure, Aymanus, with respect. I am saying on interpretation. This case is cited and the article is cited only for an approach to interpretation.
And, we are not here using the Constitution or utilizing the text of the Constitution to either read down a statute or to strike down a statute. That's one element of the impact of the Constitution. The other thing which we are doing now here is expanding the meaning of a statute in the context of constitutional guarantees. And in that, you are saying be liberated from the bare text of the Constitution or the notion of parliament.
The first part of what I argued yesterday was dignity, non-discrimination.
See, in the backdrop of constitutional interpretation, we have never used the originalist doctrine, right? India, unlike say what Justice Kalia said, we have never regarded ourselves as bound by an originalist interpretation.
Kalia is an extreme example.
In which case, Dr. Singhvi, if we have never been bound by an originalist interpretation of the Constitution, should we be bound by an originalist interpretation of the statute? Which is in that sense subordinate to a Constitution.
And he, Their Lordship knows that a court of one. He said, if I'm the only one, I'll always stick to this original intent. Court of one. So, your basic, all that I'm saying is, one, because I've done the constitutional aspect, yes, unless your Lordship anchors it in the values of 14, 15, 16, 19, 21. That's the first
part. But to put it really bluntly, is the relationship between a man and a woman so fundamental to our law and therefore the Special Marriage Act that for us to comprehend that it will also include a relationship between a same-sex couple would be completely redoing the tapestry of the legislation. So
this
if we say yes, then obviously we cannot.
The underlying agnostic thrust is the underlying agnostic thrust of SMA, antithetical to your Lordship's recognizing what Article 14 normally will always include, namely same-sex persons enjoying the same importance and benefits of marriage as different sex persons. That's the long and short of it. As an aid to interpretation, I've only cited one case which says, and only interpreted statutory out of the Constitution. Does the underlying thrust, alternatively, an interpretation of SMA, prohibit or preclude your Lordship from doing so? Or is your Lordship's institutional capacity so compromised by a particular case that your Lordships cannot do it? That's the fourfold way, connecting yesterday and today.
And really, your argument is that, the institution of marriage in itself is so very important that
to
to deny it to same-sex couples would be really contrary to fundamental constitutional values.
Sorry to interrupt, my Lord the Chief Justice, but my note yesterday, I said it, para 15 lists 7 important indicia of marriage, and the appendix
Correct.
lists more. Their counter says so. I rely on it heavily. The question is only exclusion. You have it for that side of the table, you don't have it decided. Para 15 of my submissions. My Lord were kind enough to note it down also by hand. Now, without that, if I was to straight away jump into an interpretation exercise of Ghaidan, it would be wrong on my part. I'm completing my argument.
All right,
I'm
Dr. Sikri, we're just reminding you it's 12:17.
No,
now, Ghaidan is over. This article is done. We've got the trust. Now, what's the next one?
The next one. Now, let's very quickly. One, I'll be very pointed. Justice Bhatt put a question to me about Justice Lahoti's order. That's 2005, 3 SCC 313. Don't bother, Malas. Just I'm giving a copy to your lordships. Just note, it was a different case. But said so yesterday. It's a different case. Context was different. It was, Malas, really about again a tenancy law invoked, Malas, by.
This was in the absence of the domestic.
Deserted wife to claim tenancy, etc. But leave that, Malas. Para 1, your lordship will note, the words are evocative. I'm just moving on. Just para 1 of that, Malas.
Dr. Singhvi, what exactly? 2005, 3 SCC?
2005, 3 SPC, 313. Just note para 1. I'll read it fast, fellows. Lordship need not open it. I'll just read it for Lordship. Only para 1. The law, it connects with what I'm saying. And therefore, your Lordship put this question to me yesterday. The law does not remain static. It does not operate in a vacuum. As social norms and values change, laws too have to be reinterpreted and recast. Law is really a dynamic instrument fashioned by society for the purpose of achieving harmonious adjustment, human relations by elimination of social tension and conflicts. I'll leave it at that, Malas. That's just a. The second thing, Malas, my Lord Justice Bhatt put to me. My Lord, remember that passage, so I've traced it out. That's only. Secondly, my Lords put to me. My Lords put to me.
The contractual relationship.
Yeah.
This is our Ghaidan moment in a different context. Our Ghaidan.
This is a kind of a Ghaidan. I mean, it's a little. Your Lordship is right. That's a tenancy case. But I'm.
You see, the interesting part is this predates the domestic violence in act.
Domestic. That's what your Lordship put to me yesterday. That's the point. That's the point. So well, static, dynamic, moving. That's the whole point. Second, my Lord put a question which will have to await research. I can't give your Lordship a different. But what is one of the examples I found? For example, in one narrow case of standard personal accident insurance, what my Lord put to me, is there a statutory regulation? There is by IRDAI, not in the mass of others, but in that, which use the phrase legally wedded spouse. Now, I will make that chart and give it later. I'm not considering, suppose your Lordship were to hold that SMA includes this form of marriage. They would be legally wedded spouse in the sense that your Lordship, after your Lordship's date of may fall within that again. But that is one of the few regulations which has the phrase. The large bulk doesn't. Where that phrase is there, it will depend, Malas, on your Lordship's judgment. But your Lordship's judgment, according to me, even where it finds same-sex persons in marriage valid, would be covered under that. I've given you a specific quote of a particular, Malas, IRDA regulation. The third thing, Malas, is how to apply this gender. Malas, the third thing is, just note in bullets, Malas, the answer on this. This is important. Your Lordship has one situation about 2B and the first schedule of the Act. Answer, both parts of both schedules will have to apply to Malad's non-heterosexual couples. The prohibited category yesterday Your Lordship discussed.
Yes.
Two parts, both parts of both schedules will have to apply to non-heterosexual. It does no violence to Your Lordship's sense of Malad's that Your Lordship is making a statutory scheme. Nothing. The statutory scheme exists. My Lord is not saying whether he and I are prohibited category. Whether he and I are prohibited. Lordship is not defining. Your Lordship is saying it will apply on both parts. That's answer number one. No violence to the underlying trust.
Can you say that again? Can you say that? Repeat that.
Yes. The two schedules in question for the issue of prohibited degrees of relationship will apply, both of them simultaneously, to all non-heterosexual couples.
That's what Mr. Rohtgi said.
That's right. So we are now ironing out Your Lordship.
Collapse into one.
Yeah. Suppose Your Lordship has to make out a prohibited relationship. That would be legislation. Suppose Your Lordship, I am asking to do something which creates something. Nothing. Your Lordship is reading in something and making it as harmonious. Second, 4C age 4 items. One I've done with prohibited degrees. Second is age. There are the 4 questions here, Malas. Age, the simple and the correct solution is, Malas, that whichever of the same-sex couple is involved, that age will apply.
Sorry?
First is prohibited degree. I've
That's
both. Second is, Malas, age. Whichever of the same-sex couple is involved, whether it is 2 ladies or 2 men, that age will apply, be it 18 or 21. I'll come to the gradations in a minute. Give me a minute. Without having any stitching to be done on a legislative cloth. Third, now the question may arise, what about trans categories? The trans categories, your Lordship will hear other people are there. My own humble submission would be, in 99% trans categories, your Lordship is able to slot the person as per the gender which he or she professes, says belongs to, claims, etc. Because a trans means a man's body but inclined to be a woman, or vice versa. So if your Lordship were to then follow that slotting, and if the person is a man, otherwise biologically in say leaning towards the feminine side, then the age of the feminine will apply, or the age of the male will apply, vice versa. The fourth point here is, the fourth point is that your Lordships will keep in mind that I am focusing on what is all these petitioners? They are focusing on the discriminatory parts of the provisions. We are not challenging every provision or interpreting every provision. We are challenging the discriminatory portions of the gendered provisions. Gender provisions which are... So we are not concerned with every provision. And certainly the government of India is not challenging any provision. So your Lordship will see only our challenges or our reconciliations where necessary. Fifthly, some provisions which may not create any confusion, like 27(1)(a) of the SMA, only an example. They are peculiarly, conceptually, designedly created and applicable only to heterosexual relationship. Rape. I mean, you cannot have a system which applies uniformly to every category.
No, why?
Rape.
Why can't it apply to a homosexual couple?
No, with a caveat. Well, it's a criminal offence which has been defined. I will find the shortest definition is non-consensual penile vaginal penetration. It's one simple way of putting it. Now, of course, it has been expanded after the Verma committee to mean other forms of but otherwise non-consensual penile vaginal interface. Penetrative. Now, it is true that as well as rape, apparently rape is a crime even by a woman or a man in France, as far as I know.